Welcome everyone. Thanks a lot for staying with us. You're watching Plain Speak with me, Shivani Gupta. A constitution bench of the Supreme Court heard a batch of petitions seeking legal recognition for same-sex marriages in India for a second straight day today. About 20 such petitions have been filed in the apex court between 2020 and 2023. The petitioners are demanding legalization of gay marriages as the law denies them matrimonial and retirement benefits. Today, the arguments continued in the direction that decriminalization of homosexuality is not enough and gays shouldn't be treated as less just because of ascriptive characteristics. Remember, the centre government has opposed these petitions on several fronts. Most importantly, that it is not a domain of the courts but of Parliament. That hasn't stopped the courts from conducting the hearings though. But today, the court did respond to the government's contention that same-sex marriage is against Indian culture and an urban elitist concept. The Supreme Court said that the government doesn't indeed have any data to prove so. It's just a belief as more urban people are coming out of the closet. Even the petitioners argued that calling it elitist ignores the struggles of the LGBT community. But interestingly, the court has mandated that while they will look into the civil union of gay couples under Special Marriage Act, they will steer clear of personal laws. Now, that's the distinction that may be okay for now for the purpose of this hearing, but will not be limited after all. Marriage is one of the most fundamental religious institutions. Let's not kid ourselves. Every religion has personal laws governing this aspect of life, and then divorce, succession, inheritance, adoptions, etc. In a country like India, touching these laws is almost impossible, even for the Supreme Court. So has it found a convenient way to skirt the issue and leave it for a later bench to deal with? Is dealing with same-sex marriages only from the prism of special marriages inherently myopic? After decriminalizing of gay sex, allowing gay marriages was going to be a natural progression. Frankly, whether you're for it or against it, stopping it is going to be virtually impossible. And with it, issues like adoption, childbearing and child-rearing rights of gay couples. So if gay marriage was to be legalized, let's say, will it not fundamentally lead to opening up of a Pandora's box from the personal laws front? And wouldn't it have been better to deal with it now than later? We'll take that question to our guest joining us in just a bit. First up, let's also tell you more about the central government's fresh affidavit in the Supreme Court. This is what it says. The plea urges Supreme Court to make all state governments and union territories party to the petitions seeking recognition of same-sex marriage. Centre says that concurrent list in the 7th schedule of the Indian Constitution includes marriage, and it also pertains to divorce, infants, minors, adoption, wills, incestacy, succession, joint family and partition. Thus, consultation with all the states is necessary for adjudication of the petition. Centre says the rights of the states, especially the right to legislate on this subject, will be affected by any decision on this subject. In fact, the centre added that it has already started the exercise of consultation with all states, even in the absence of a notice to them, and they argued or pleaded that in the alternative that they are not sent a notice, the centre should be allowed to finish the consultative process with the states, obtain their views, apprehensions, compile the same and place it on record. In fact, the centre had brought up this issue yesterday as well. Just for context, here are some of the key submissions that the SG Solicitor General made yesterday on the first day of the hearings on behalf of the government. First thing, creation of socio-legal relationship of marriage is the domain of the legislature. This subject is in the concurrent list. All states may not agree. The SC also brought up the issue of maintainability, adding that there are repercussions if the court decides on this. He added that they should be given time to consider to what extent the government would want to participate. And finally, the SG said, this is not an issue that few minds on each side and a bench can decide. The court was not inclined to quash the petitions on the ground of maintainability, with CJI D.Y. Chandrachud interjecting the SG and stating that the nature of the SG's preliminary objection depended upon the canvas of the petitioners. And he added that once we have a picture on what is the canvas they're arguing on, we may tell them what is the canvas we want them to argue on. In other case, they've brushed aside the maintainability issue for now. Now, what was interesting is that the court clarified that for now, it would be limiting itself to the ambit of Special Marriage Act and not personal laws. The CJI said that we can, at this stage, steer clear of personal law, adding that it may not be necessary for the court to get into personal law at this stage. Now, even to this, SG Tushar Mehta objected and said that whether the court liked it or not, the hearings would necessarily affect personal laws. There is just going to be a rippling effect. What was also interesting is how the court decided it will not go into personal laws at this stage, despite the insistence from senior advocate Menika Gulswami, representing a petitioner who had sought an expansive reading of the Hindu Marriage Act to include queer marriages. She said the Hindu Marriage Act is not an issue necessarily of personal law, it's a statutory law. It has in the past allowed something that was not permitted in sacramental Hindu law, like intercaste marriages, sagotra marriages, etc. But the bench did not seem eager to entertain arguments on marriage equality in the Hindu Marriage Act. At this juncture, the CJI said there may be some amount of wisdom in going about our tasks in an incremental manner, because otherwise, how do we confine ourselves to Hindu Marriage Act alone? What about Parsis, Jews and Muslims? So they decided they will not get into any of it. A reminder of the main submissions by advocate Mukul Rohatgi on behalf of the petitioners. He argued that now homosexuals have the same right as heterosexuals after the decriminalization of gay sex. He added that marriage should be declared a fundamental right for gays too, adding that the state cannot say that we can just leave you alone now because we've removed 377. We want to enjoy the full extent of our rights. Remember, petitioners also argue that they can't avail for a lot of benefits like insurance that other married couples can. He also added that while decriminalization gave them privacy in their homes, they also want dignity in public space. And finally, that the state should allow gay marriages to be recognized under the Special Marriages Act. Senior advocate Rakesh Dwivedi, while praying for states to be included as parties in these petitions, also brought out the counter view to same-sex marriages. He argued that gay couples cannot be treated at par with heterosexuals or have absolute equality. He added, heterosexual couples perpetuate the human race. It's a core component of these unions, if not the entire component. Marriage amongst heterosexuals is not the gift of law. In other words, it doesn't happen because the constitution allows it. It existed since the Rig Veda or from time immemorial. Same-sex is not a new phenomenon, he said. It existed earlier too, just that they didn't claim equality. And finally, that the two unions are different, they cannot be put on the same pedestal. The big debate that's coming up, gay marriage legalization. If we were to move into that direction, at this stage, leaving aside personal laws, will that not lead to opening up of a Pandora box?